So similarly herein, rules are parameters, rules are yardsticks that help us in understanding whether our conduct is in accordance with those rules or we are
Wonderful,
deviating
beta.
from the same. Moving ahead, he says that existence of legal rules. Because of legal rules, our conduct, human conduct, is the nature of the human conduct is non-optional and obligatory. It becomes an obligation. For example, if rule is there, 75% attendance is mandate. You have not seen those times wherein, you know, people had to face music for the 75% attendance. You talk to your uh, 2018 batch, 2018 to pass out over the 2018. You talk to them once. Apparently, they'll say that नहीं attendance का कुछ नहीं है ऐसा नहीं. I mean, I had registers with me of all the reasons when I was class in charge, of all the reasons for compliance, non-compliance, parents coming, parents meeting, parents, coming and giving the apology. No, no, ma'am, my ward will attend the classes and so and so. All thanks to pandemic. So this conduct has been made non-optional. Sorry, it this conduct has been made optional and non-obligatory, but otherwise it has always been it has always been non-optional and obligatory. So thereafter we dealt with the external point of view and internal point of view. External point of view, we worked on observation and thereof an internal point of view. Internal point of view, inner realization. This was a point of critique, point of criticism of John Austin's theory, that theory of command. That he says that command, it is because of the fact that commands are issued by the sovereign and they are backed by sanction. The fear of sanction, which propels all of you, propels the people, the subjects, to follow the command. But on the contrary, when Professor H.L.A. Hart had criticized the theory of command of given by John Austin, he says that no, it is not always the fear of sanction which propels us, which forces us, or which sometimes encourages us to follow the command. Rather, this internal realization, the factors for internal realization, CRA, critical reflective attitude or application of mind, it varies. Internal factors vary. One wants to become a judge, that is why he is doing law. The other one wants to become a corporate professional, that is why he is doing law. The third one, he wants to join academic, that is why. Fourth one, he did not had any other option. But all of them are doing law, and all of them are all of them, the external observation is that ABCD all are doing law. But internal realization is why they are complying with 75% attendance. एक के पास opportunity थी नहीं थी, दूसरे को corporate lawyer बनना है, third has to become a judicial officer, and fourth has to join academics. So internal reasons, they vary. So reasons for following the directions vary from person to person. According to Professor H.L.A. Hart, it is not always the fear of sanction which is a reason behind us following the directions. Thereafter, moving ahead, we came to this point that legal system is combination of union of primary rules and secondary rules. Now, what are primary rules? What are secondary rules? Primary rules, what are primary rules? What are secondary rules? And if societies are, if in a society only primary rules are there, then they are termed as primitive societies and they suffer from these three deficiencies. These three deficiencies: uncertainty, staticness, inefficiency. We'll take up this today. And thereafter, I'll take you to Hans Kelsen from this point. I'll be sharing one article on it is basically a comparison between John Austin, Professor H.L.A. Hart, and Kelsen, only with respect to command. So just go through that. That will be an additional reading. So go through that, and Kelsen will study his theory from his article, which was published in Harvard Law Review. Only the highlighted portion we'll take up during the classes. Rest you can read on your own. Coming back to the topic, now only what are primary rules and what are secondary rules? Primary rules and secondary rules. Hmm? Primary rules are the rules that determine the relations, that determine the duties, rights, and duties of the subjects, of the people. And thereafter, he says that secondary rules are the rules that determine the composition of courts, administrative tribunals, right? Police officials, their composition, the procedure which is to be followed by them, their role is defined, their jurisdiction is defined. Those are secondary rules. Now, whenever you will prepare for any competitive exam, you will have to study CPC evidence limitation. CPC evidence limitation along with the substantive laws, contract law 1, contract law 2. Okay, this will be the combination. Thereafter, when you will study for criminal law paper, then you will have to study what? CRPC, evidence, and IPC. So this will be the combination. Now, understand this. IPC, let's take example. IPC envisages that an act will be set. It is, if a person will act in a particular manner, then it will be said to be an offense, a punishable offense. Now, CRPC tells us about the procedure. If an accused is arrested, what are his rights? What are the duties of, what are the powers as well as what are the duties of the police or the arresting officer? Thereafter, what, again, the example of confession 164 of CRPC. It is the duty of the magistrate to ensure the nature of the voluntariness of the confession. Then only it will be admissible, otherwise it will not be. Hierarchy of the courts, criminal courts, hierarchy of the criminal courts. Thereafter, the sentencing power. If I'm not wrong, 28, 29 onwards, these two sections. There is a difference between who can take the cognizance and trying the offense. I hope you all understand the difference between the two. Cognizance is application of judicial mind and trial. A court can take cognizance, but it cannot try. Any court can take cognizance, for example, but it cannot try. You will be studying it you will be studying it as a part of your CRPC lectures, during your CRPC lectures. Cognizance is different and trial is different. Trying is different. Cognizance and try can also be there. So what is this all about? These are the provisions. These are the CRPC lays down the procedure, the power of the courts. Say 177 onwards, the jurisdiction of the court, of the criminal courts. If bail has to be granted, then what are the kinds of bail? What are the parameters? What are the considerations? What factors are taken into consideration while allowing the bail application or while rejecting the bail application? Everything has been laid down in CRPC. So it is basically, now you go back to the initial ADR class, CRPC class or CPC class, wherein philosophical analysis, wherein jurisprudential analysis of a law is done. That is ubi jus ebi remedium. Wherever there is a law, wherever there is a right, there has to be a remedy. Right है, remedy होगा उसकी violation के लिए. Right नहीं है, remedy के बिना there can be no right without remedy per se for its violation. Remedy has to be there. So going back to the last discussion also, substantive law interlinked with procedure law, read with limitation and evidence. Limitation for civil side and evidences for both Thereafter, if you have come to ADR processes, Lok Adalat, mediation center, institution mediation, pre-marriage counseling, dispute, these counselors are there. Family Courts Act Section 12 talks about there is a provision for counselors before applying to the court, even before mediation, there is a provision for counselors. How far this provision is being utilized, that is a separate issue. Hmm? So what are these laws, these acts are, and Section 19 onwards of Hindu Marriage Act, it tells you about jurisdiction, it tells you about powers of the court also. Thereafter, it talks about alimony 24, 25, maintenance, pendant and alimony. What are these? These are guiding rules. These are guiding rules that this is the jurisdiction of the courts, and these are the powers. This is the jurisdiction, powers. Thereafter, this is how it is to be followed. Steps. If you start from order 6, rather if you start from section 9 of CPC, it is considered to be gateway into CPC. Thereafter, you will understand filing of the institution of the suit. Order 4 read, section 26 order read with order 4. Thereafter, you will proceed further to what are pleadings. Order 6 will apply on not only on plain and written statement, but all the application. You will proceed towards first step will be filing of the plaint. It can be rejected. It can be returned. The grounds. All these are basic, and thereafter guidance is being given to the courts. Okay, so about procedural capacities and procedural norms. So in case of primitive societies, kinship, or the culture was the culture. Different communities had I had drawn a diagram here, if I am right. If I correctly remember, I had drawn diagram. Anyways, C1, C2, C3, C4, C5, and the list goes on. Various communities where they were governed by their own rules. So they all were scattered. Scattered, and unification was not there. They were not unified. They were not recognized. There was no uniformity. So thus this defect in primitive society without secondary rules. Primitive society is a society wherein secondary rules were not there. So secondary rules were introduced. Secondary rules of recognition was introduced. Recognition means determination. बोलते ना recognize किया. अगर मैंने अच्छा काम करा, मेरे को recognition मिली. What is recognition? It is assertion. Asserting that yes, these are the rules which will be applied. ठीक है, certainty. ठीक है ना, certainty. Categorization, that these are the unified rules, these are the uniform rules which will be applied in a given situation. Rules of recognition. Thereafter, staticness. See, in last lecture also I had said this, that if law works as a catalyst, law works as an instrument to bring social change. If law would have not been there, then it would not have been that easy to bring change in the society. I know it is with law also, it is difficult to bring change, because it is the game of it all depends on the mindset, and it all depends on the society in which we live. But law plays a vital role in bringing social change. We'll talk about efficacy of law in Kelson, at the time of Kelson also, and thereafter when we'll study sociological jurisprudence. So, rules of change. Now you correlate this with amendment. Why amendment? Why? What is the purpose of amendment? What is the purpose of repealing statutes? What is the purpose of amendment? It is to bring change. It is to bring the law at par with the advancement in the society. Sometimes it is to correct the legislature's presumption is this is a rule of interpretation of statutes that legislature does not commit mistake. But if it has committed mistake, then it can be rectified by it only, isn't it? So what is the purpose of amendment? Technology, advancement of technology. You saw amendment in your Evidence Act. Advancement, and the Consumer Protection Act 2019. Why? Specific Relief Act has been amended in 2018. Why? Because there was an urgent need. It was the change in the law was need of hour. Now, why we are progressing towards mediation law? It's not a difficult task, but still we are progressing. I mean we are taking. It's been so long that we are not able to conclude. We see amendment. It includes change also. Change in policy, change in bylaws, change in rules, change in regulations. So secondary rules of change. So if you understand this, Parliament has power to make the laws, Parliament has power to amend the same. Same goes with state legislature. If any authority is okay, now you let's go back to Supreme Court regulations 1996. Thereafter, we had dealt with NALSA regulations. The changes were brought in 2019 and we had discussed in the class. Those even the statutory instruments, even the rules and regulations, the authorities they have power to change. Now the standard SOPs have been issued for e-lok adalats. SOPs have been issued for online application of pre-mediation, pre-suit institution mediations. So since the atmosphere changed, since the circumstances changed, the requirement changed, we had to change. अगर अभी भी हम कहते no, we can't use Cisco WebEx, we can't, I can't, parties can't, I don't have money, or for that matter, I can't adapt this change, then what would have been the position? It would have become, the justice delivery system would have come to, it would have experienced an halt. So thus secondary rules of change, they are imperative to ensure that the transition of society from pre-legal state order to pre-legal state order to develop system to to develop legal system or legal state order. Are you all here with me? Shall I proceed further? Ho kya? Raise your hands. And why don't you take deadline seriously? Where are your research topics? Ayush Sharma is not there in the class? Okay, he is there.
Oh, ma'am, I'm here.
All right. Fine, beta. Chalo. I'll wind up by 1:15. I'll try to. Okay, 1:15. Thereafter 5 minutes for attendance. 1:20. Moving ahead, last effect is inefficiency. Inefficiency. बोलते हैं गोल पता हो. अच्छा, all of you, you subscribe to Harvard Business Review. ठीक है, HBR LinkedIn पर है. इस And in case if I'll come across some good articles, which I usually do every day, I read one article on this whenever I find it interesting. So I'll share it. If you all are interested, I'll share on the wall. So yes, so I was correlating this. When you know the goal, but you do not know the way. When you know the goal, but you do not know the way, then this is only a dream. But when you know your what is your goal and you know the way also and you are implementing, then this dream becomes reality. Yes, so this dream becomes reality. So that is the case with procedural laws. That is the philosophy behind procedural laws. You have rights with you. How to implement, where to implement, who are supposed to implement. Hmm? Procedural laws. Thereafter, going ahead traditional and thereafter moving ahead to ADR processes also. This is their role that ठीक right है, violate हुआ. These are the processes. We are not talking about efficacy here, how far they are being implemented. No, we are just talking about their importance. Secondary rules of adjudication. Inefficiency. Yes, हाँ, inefficiency को ऐसे, अब तुम्हारा गोल सेट है बट रास्ता नहीं है. Or if you know the way but the authorities or your guy your mentors are playing their role well, but they are not, but it can be improved, and similarly your efforts can also be improved. If way implementation of way is inefficient, or your goal is, you have not um, you have not uh, crystallized, you have not prepared it in crystallized form, pata nahi kahan jana kinds. So ultimately inefficiency is bound to happen. If you'll not have authorities with you, if you'll not have mentors with you, then inefficiency is bound to happen. Or if you will not adopt their advice, then inefficiency is bound to happen. You can be your own mentor also, isn't it? If you'll not follow your own advice, then also the inefficiency is bound to happen. Similarly, rules of adjudication were required. Inefficiency was there. Why inefficiency was there? Because authorities were not there. Yes, and their roles, their procedure were not defined. So he says that this this problem of this defect of inefficiency can be fixed by introducing secondary rules of adjudication. Now, what is adjudication? Adjudicate means adjudicate means to decide the rights of the parties, to give an order. A versus B, we have traveled from versus to A and B. This represents traditional court system, this represents ADR. A and B. So whatever discussion we had done on procedural laws, please incorporate here in rules of adjudication. Okay? Why substantive, why procedure? You'll start with obj ab remedium. Thereafter, you'll explain with the help of the philosophy behind CPC, CRPC evidence, and together, and this your ADR processes, why adjudication, why authorities, why their role has to be defined. Why defining the roles of authority is imperative. You'll explain this concept with the help of examples here. So I'll move ahead. Hart's criticism, and there was one more point on sovereignty we'll take up afterwards. So this is this was all about heart, and this is just a beginning. These are basic points because Professor H.L.A. Hart, John Austin, Hans Kelsen, they are one sub point of unit 1. Okay. So yeah, Hans Kelsen. Hans Kelsen so, is positivist, and we'll after him Joseph Raz, uh, or many other thinkers are there, but jurists are there, but you restrict yourselves to 4 under analytical positivism. Now he says that what is law? What is law in the terms of Hans Kelsen? Law postulates norms. Law postulates norms. Or what are norms? He says these are orders. Order, but not in the form of command of sovereign. Order hai, but it is not in the form of command of sovereign. Now by this order, this is an order by which human conduct is regulated. Human conduct is regulated in a specific way. In a specific way, individuals ought to conduct himself as the norm says, according to the norm. Now understand, what are norms? What is law according to him? He says that law postulates norms, meaning thereby laws are norms, normative science, normative jurisprudence. He talks about norms. Now, what are norms? They direct us, they by order regulate our conduct. That human conduct is regulated in a specific way. That human conduct or human beings should behave in a should behave is a wrong word. Rather, you use these terms only specific term. That these are the orders. Norms are the orders through which human conduct is regulated in specific way. These are the norms tell it, they direct human beings to conduct themselves in a specific way. One, they ought to conduct themselves in a specific way. They ought to conduct. Now, ought to conduct. There is a difference between ought to conduct and efficacy, validity and efficacy. You ought to attend the classes regularly. You ought to submit the PhDs on time. You ought to apply for internship. You ought to sit and study for your competitive exams. You ought to do this. You ought to exercise. You ought to take care of your mental health. You ought to follow a schedule. You ought to. But he says that this norm, laying down the norms, it does not ensure that you will. It does not ensures the efficacy of the norms which have been set by the which have been stated. Efficacy means effectiveness. ऐसा करो, ऐसा करो, आप करोगे ये जरूरी नहीं है. Laying down norms does not ensure efficacy. You ought to do this. This is the ideal conduct. But whether you will comply with it, whether you will follow it, whether it will be efficacious or not, that is a separate kind thing. Validity and efficacy, he says, they both are two different things. And validity, he says, is subject matter of analytical jurisprudence, and efficacy is subject matter of sociological jurisprudence. This is what he has written in his work. Thereafter, moving ahead, legal norms, general norms, legal norms too, he says that legal norms or legal system is unification again of two, general and individual norms. General and individual norms. Now, general norm, you understand general norm. Tomorrow I'll take you to hierarchy of norms, last 2 minutes, and we'll cover this theory tomorrow. So general norms and individual norms. Understand it. General norms is, we all know that commission of any act which amounts to theft is a punishable offense. commission of any act which amounts to culpable homicide, amounting to murder, not amounting to murder, they are punishable offense. Causing grievous hurt is a punishable offense. Causing, yes, and the list goes on. Any person, वो बोलते हैं ना, any person, उसमें किसी का नाम नहीं लिखा हुआ. Any person who so does so and so shall be punished. So and so shall be punished with so and so. This will be the punishment, this will be the fine. So this is a general norm. This is a general norm. And when this norm is applied to a particular person, that is A has committed theft, he will be, he's an accused and he'll be punished. He has been proven guilty, thus he will be punished. The application of norm on a particular individual is he says that these are individual norms. Application, ये उसमें भी पढ़ा होगा तुमने, लॉ ऑफ टॉर्ट्स में भी पढ़ा होगा, न्यूसेंस में भी पढ़ते हैं. ठीक है, एक इंडिविजुअल व्हेन ही कमिट्स द ऑफेंस. ठीक, अदरवाइज इट इज अ जनरल रूल अनलेस एंड अनटिल इट इज डन बाय अ पर्टिकुलर इंडिविजुअल. So we'll come back to this again tomorrow. Individual norm, hierarchy of norms, concept of grand norm, efficacy, and thereafter pure theory of law. So tomorrow we'll wind up analytical positivism. Any doubts? समझ में आता है या OHT होता है? Tomorrow we'll meet at, yes.
Ma'am, can you please explain how the secondary rule of recognition helps counter uncertainty?
Yes, sure. Samiksha, right?
Yes,
Was
ma'am.
okay, fine. I'll just take attendance first and thereafter I'll explain. Arnav, Anamika, Karanveer. All of you can see the attendance list. Arnav is there, Anamika?
Yeah. I'm Anamika present.